very short docket, only 2 cases this morning. They'll be heard in the order in which they appear on that docket. If council's ready, we'll hear the case of Lucas versus Englewood, Indiana.
May it please the court. My name is Bill McCabe. I represent the claimant Vicki Lucas. I'll reserve 2 minutes for rebuttal. In this case, we contend that Florida Statute 440-2011C 2001 is unconstitutional as a violation of the claimant's constitutional right of equal protection because an unrepresented claimant would be automatically entitled to a 20% penalty for late payment of settlement proceeds, whereas a represented claimant is not. Prior to October 1st, 2001, which is the date that this statute went into effect, represented claimants and unrepresented claimants were treated equally when settling their workers' compensation claims. Both had to have their settlement approved by a judge before it was considered a valid and binding settlement. Represented claimants and unrepresented claimants were both automatically entitled to a 20% penalty if the settlement proceeds were paid late. This is because a settlement proceed was considered an award, and Florida Statute 440-27, which is the penalty statute, provides for the payment of a 20% penalty for the late payment of an award. Now, all that changed, and by the way, the case is also held that the late payment of penalties was mandatory, or the payment of penalties for late payment of settlement proceeds was mandatory. Now, the settlement statute was changed effective October 1st, 2001.
When this case was settled, could the parties have agreed that the payments will be made within 5 days, or there would be a 20% penalty? Could they have put that in their agreement?
They could have, yes.
Could they have said, we'll allow you 30 days to pay the settlement proceeds?
They could have, yes.
So that doesn't provide a rational basis for the legislature to allow that flexibility for the represented claimant to be treated differently than an unrepresented claimant?
Well, I would say no, because they're not starting from the same platform.
Well, yeah, true. The represented claimant has an attorney representing him, and so the legislature would allow more flexibility in their negotiation process.
Why should it be any different? I mean, a represented claimant, in order to get penalties, has to affirmatively negotiate them in the contract.
Is it unconstitutional, then, that the unrepresented claimant has to have their settlement approved and the represented does not?
Well, I think that there's a rational basis for that, because the unrepresented claimant doesn't really have anybody professional, if you will, looking out for them when they do their settlement, and that's where the judge of compensation claims comes in.
And so for the legislature to fill in some of those terms, like payment will be made within 14 days on a settlement, there will be a 20% penalty if it isn't paid. For the unrepresented claimant, that's not the same nature of looking out for the unrepresented claimant?
Those are substantive benefits. I mean, a 20% penalty is a substantive monetary amount that a claimant is entitled to for the late payment of settlement proceeds. And a represented claimant needs his money just as fast and as timely as an unrepresented claimant. The purpose of the penalty statute is to assure prompt payment of claims.
But Ms. Lucas could have requested the same penalty or even a greater penalty, couldn't she, when she agreed to settle the case?
Say that again, I'm sorry.
The claimant here could have asked for the same penalty if not paid within 14 days, or could have asked for even a greater penalty, couldn't they?
They can, and unrepresented claimants can negotiate too, but the point is that they don't start at the same platform. They're not treated equally in the statutes. And like I say, an unrepresented claimant has to be negotiated out of his settlement agreement, whereas a represented claimant, it has to be negotiated in. And there's absolutely no rational basis to treat a claimant differently when it comes to substantive benefits than an unrepresented claimant. It just absolutely makes no sense whatsoever. Like I say, represented claimants need their money just as bad as an unrepresented claimant. And, you know, it's just, I just can't think of any rational basis for it. The procedural steps, I agree, there is a rational basis for it. But when you get to the substantive benefits and the amount of money a claimant's entitled to get if the payment is late, there's no rational basis for distinguishing between a represented claimant and an unrepresented claimant. And basically, I mean, that's the argument in a nutshell. Obviously, there's no cases on this. I know it's difficult to find statutes unconstitutional. I agree that the rational basis test is the test in this particular case. It's not one of those heightened scrutiny type of cases. But, just to provide different benefits because somebody's represented is just completely arbitrary. And that's basically the argument in a nutshell. I'll reserve the rest of the time for rebuttal.
May it please the Court. Good morning, Your Honors. My name is Mark Tinker. I'm with Fowler White Boggs Banker in St. Petersburg. I represent the Appalese Englewood Community Hospital in Broadspire. The challenge to the constitutionality of this statute is an equal protection challenge regarding the legislature's decision to create, as it's been phrased by Mr. McCabe, two separate classifications. Since this doesn't involve any suspect classifications, however, this Court should apply the rational basis test. And there are a few things that we start out with when we're applying that test. Number one, as with all statutes, the statute comes here with a presumption of constitutionality. The Court has to presume it valid from the outset. And the second is applying that rational basis test. The Court's only concern is to look for any set of facts that would sustain the legislature's decision to do what they did. It doesn't have to look to the wisdom of those facts or whether the Court thinks that there was better ideas or better ways that the statute could have been organized. The only thing that you're looking for is whether any state of facts could sustain this statute. And we submit that there absolutely is, both at oral argument today and in the reply brief. Mr. McCabe, on behalf of the claimant, has conceded that the settlement approval procedures do bear a rational relationship in this context. That since an unrepresented claimant doesn't have the protection of counsel, doesn't have sophistication in that regard, the JCC is effectively substituted as counsel and goes through and makes certain findings of facts, conclusions of law, makes sure that everything is appropriate with the settlement before it's approved.
Mr. Tinker, why do you think the legislature provided only 7 days for payment in connection with a washout settlement for an unrepresented defendant, but provided 14 days for a represented defendant?
I do not have a good answer to that, and it kind of confuses me as well. Again, my initial answer to that would be that, again, as I just stated, it's not this Court's job to look at the wisdom of why they chose 14 days versus 7 days.
Well, what would be the rational basis for that distinction, do you think?
The rational basis is likely if you have a represented claimant, and as we've been discussing, they're in a situation where they're going to freely negotiate the terms of their settlement as opposed to having the JCC oversee everything. This is something that may have unique terms, may be different from just your ordinary run-of-the-mill settlement, and that provides an extra amount of time.
Do you think that 14 days is something that can be negotiated when the legislature specifically said that the amount must be paid within 14 days?
I believe that it can be negotiated, yes.
So that mandatory language is not really mandatory?
That sets what the legislature believed to be an outer limit. It doesn't say that it shall not be paid before 14 days. It is something that the parties could negotiate.
Well, they weren't paid within 14 days in this case, were they? At least part of the.
They were paid 3 days late, a part of the benefits. Yes.
What's the consequence of not paying within 14 days?
In this case, since the parties did not put anything in their agreement regarding that, there is no consequence.
Well, there was nothing in the agreement about the time within which the payment was supposed to be made?
No, Your Honor.
I thought I recalled that there was a provision in the settlement for it to be paid within 14 days, but I might be mistaken about that.
And I apologize, I believe you're right. There was a provision saying within 14 days there was no penalty attached to it. There was no statement that a penalty would apply, or that, for example, the 20% penalty provisions would apply, or any other provisions.
So the settlement agreement said that there would be no penalty so long as the payment was made within 14 days.
It didn't say that it didn't address penalties at all. It didn't say that.
What did the language in the settlement agreement say?
Simply said that payment was to be made within 14 days, and then did not attach a penalty to it, did not say that any interest would bear or anything after that point.
Are you involved in negotiation of these washout settlements in your practice?
Me personally, no, I'm not, Your Honor.
All right, thank you.
Counsel, do you agree that the 20% penalty provision is a substantive right?
I agree that it's a right that the legislature had put in place in prior versions of the statute. I do not agree that it's a right that necessarily must remain in the workers' compensation scheme for it to remain constitutional. This is something.
If it is there, is it a substantive right? I mean, the legislature can take those away.
Yes, correct. I agree that it was a right that existed in the prior version.
It's not just a procedural process.
Correct. Correct. It is a right to payment of a penalty in the event that the benefits aren't paid on time.
Well, I, like Mr. McCabe, have some concern as to what the rationale there is for some claimants to be entitled to a substantive benefit and others not, when they're identically situated, except for the fact that one has a lawyer and one doesn't.
The legislature, again, what I believe that they're attempting to do is to promote settlement of claims. And in order to promote that, they set up the procedure where if a claimant is represented by counsel, they have the ability to freely negotiate any terms they see fit. There are no mandatory requirements that are in place. They can negotiate the terms that they're happy with and that they would like. If they would like to attach greater penalties, lesser penalties, have different time frames for payment, they are allowed to freely negotiate those so that everyone's happy in the settlement. By allowing that free negotiation, the legislature has created a system where represented parties can try to achieve a settlement. They've helped to promote settlement.
So if a lawyer then fails to put a penalty provision in a settlement, and the statute says it has to be paid within 14 days, and the carrier just decides they don't want to pay it, and they'll let 6 months run by before they can get a hearing before the JCC to some kind of enforcement or go to circuit court, that's okay.
Well, it's
Simply because there was a lawyer involved. Perhaps the lawyer should be sued.
It's not okay, and that's part of the thing, is it does not leave the claimant necessarily without a remedy. There are two things. One is this court has recognized that the JCC is authorized to award a penalty if the carrier is willfully withholding payment. And in your situation, if this went 6 months and nobody's doing anything, the JCC has discretion to look at that and say, you're withholding payment. I find a willful violation and impose sanctions in the form of a penalty. On the other hand, if it's the lawyer's fault, if the lawyer is dragging the feet and not representing the claimant as they're bound to do, both by probably their agreement with the claimant and the ethics rules, the bar rules, then the claimant arguably has a claim against the lawyer also. So it's not a situation where the claimant would be without a remedy. But I also believe that, again, as part of this discussion, we're looking at what we perceive to be the wisdom of what the legislature has done, not whether there's a basis for them to do what they have done. Whether I agree with you that I believe it's strange that it's 14 days versus 7 days, whether it's something that they should have removed the penalty or not, whether it helps to promote the purpose, I believe that there's a factual basis that supports that. They've allowed parties that are represented by counsel to freely negotiate their settlements however they see fit. That promotes settlement of workers' compensation claims, and that's a rational basis for the statute.
So the theory was, as is suggested by the opening language in subsection 11C, that when a represented claimant negotiates a settlement, basically the act is just out of play. It says that when a claimant is represented by counsel, the claimant may waive all rights to any and all benefits under this chapter by entering into a settlement agreement releasing the employer.
Correct.
So the idea is that the legislative scheme was to say in the case of represented claimants, the 440 just really doesn't have any application. And what does have application will be the negotiated contract between the parties, subject only to approval of the attorney's fees by the judge of compensation claims.
Correct. If they choose to enter a settlement, they give up both their right to future benefits and the right to this certain protections that may be under the act. So they're negotiating the terms of what they would like. It's with a represented party as an arm's length transaction between both sides. They put the terms in that they see fit.
Well, does the fact that the judge of compensation claims has to basically approve all of the terms of a washout settlement for an unrepresented defendant suggests that in that case, the legislative scheme was not to take 440 out of play in the case of a washout settlement.
The legislative scheme was still to allow parties to settle, but they provide the JCC as a sort of substitute for the attorney. The JCC is going to look out for the claimant's best interest, make findings of fact that this is something that the claimant would be in the claimant's best interest, that would aid in the rehabilitation of the injured worker. The JCC makes those findings, which would ordinarily be something that the attorney would do, to look and see, is this in the best interest of my client to forego any right to seek future benefits and get this washout settlement at this point in time.
So the idea is they put the 20% penalty in there to make sure that this lawyer JCC negotiates a good term for late payment for the claimant.
That would be substituting on the enforcement end, whereas the represented claimant could have the attorney negotiate for what's the time frame for payment and what's going to be the penalty. This just says if we're going to have the JCC fill this role, we're going to go ahead and say that this is what the standards are going to be. So the JCC.
Under the statute, then the JCC could waive the 20 days and allow them, say, 60 days or 120 days to pay.
I do not believe that under the way the statute is written right now that it is something that JCC would have discretion to do in that context. No, the statute is worded and the mandatory says it shall apply when you have an unrepresented claimant.
You're saying the penalty shall apply?
In the case of an unrepresented claimant, correct?
I thought Judge Barfield's question was, would the unrepresented claimant be able to sit down with the EC and for some reason say, okay, I want so much now and then I want to wait until after the first year and get so much more, which would be 45 days from now or something, versus payment within 7. And I thought Judge Barfield was asking you, would that be okay? Could the JC approve that?
Actually, I want to know if the JCC, when he approves this settlement, waive the 20 days, the 20% penalty in 7 days. Could just extend it out, since he's in the place of the lawyer looking out for the benefit of the claimant.
What I suppose could happen, I suppose this would kind of combine both of your questions, is if you have a situation where the claimant would like a structured payment situation, they're establishing due dates for the settlement payments, and arguably the penalty would not apply until the 7 days after that due date had passed. So I believe that you could establish the structured payment schedule, have different due dates, but the way the statute is worded, to answer your question, I do not believe that the JCC has the ability to say, I'm going to disregard the 7 days past the due date and you have 60 days, just the way that the statute is worded at this point in time.
So JCC would in effect do what a lawyer would do, except he can't waive the penalty.
And on the unrepresented claimant situation, yes, it's all structured in the statute. If you have a represented claimant, then the attorney is free to negotiate on behalf of the client. And again, just going back to the rational basis test, the only thing we have to look at with that distinction is whether any set of facts sustains having that distinction in place in the statutes. And I believe promoting settlement does. It allows represented claimants to freely negotiate their terms as they see fit, while at the same time providing protection for unrepresented claimants by substituting the JCC. And at the same time, I know there are certain things that I'm saying the JCC can't do that an attorney could do for a represented client. This is saving, as I believe Mr. McCabe put in his brief, it's something that bears a rational basis because it's saving the JCC time. It already has to go through and make these findings of fact, but it's saying you don't have to draw up this big agreement where you describe the penalties, describe the payment terms, everything. It's establishing some things as automatic, the other things the JCC does on behalf of the unrepresented claimant. If you have counsel representing a claimant, then all of those things can be freely negotiated in order to help promote the settlement. If there are no further questions, we simply ask that you find the statute constitutional and affirm. Thank you.
Just in response to the agreement on page 68, they did say that the parties acknowledge that payment of the settlement monies is to be made within 14 days after the date the judge of compensation claims mails the order approving the attorney's fee and or allocation of child support arrearages. Doesn't say anything after that as to what happens if they don't. And that's really just tracking the language in the statute. And even though the statute says it must be paid within 14 days, nothing happens if it's not. The only way that sanctions can be imposed is if a judge finds that the employer carrier was in deliberate defiance of the judge's order.
Well, you'd be entitled to interest, surely.
Beg your pardon?
The claimant would be entitled to interest, surely.
They should. I mean, that really hasn't been argued in this, but I would say yes, they should. But proving defiance of a judge's order is not that easy. And in this case, for example, I think the adjuster that actually testified was the third adjuster that had been on the case since the case was settled. And she doesn't know why the monies weren't paid on time. I mean, how do you find willfulness there? Paper might have been put in the wrong stack or something. In the meantime, the claimant's not getting his money. And yeah, there might be some other remedies the claimant can do, but why should a represented claimant have to jump through all these hoops when an unrepresented claimant is automatically entitled to the 20% penalty? I haven't heard a single rational basis for distinguishing between represented and unrepresented claimants when it comes to the payment of the 20% penalty for late payment of the settlement proceeds. And an unrepresented claimant, when they settle their case, they also give up all their rights under the Workers' Compensation Act, too, for the lump sum settlement. Here's your money. We don't owe you anything else. So we would ask that the court find the statute is unconstitutional to the extent that it precludes a represented claimant from automatically receiving the 20% penalty when an unrepresented claimant gets it. Thank you.
Thank you very much.